The way that maintenance works in South African law is that there is a reciprocal duty on both parties to maintain the minor child born of the marriage, or any child that was born out of wedlock. Parties have to pay maintenance according to what they each earn. So, if, for example, one spouse earns 4 times more than the other spouse, then that party would have to contribute 4 times more towards the maintenance of the child. In terms of the New Children's Act, the age of majority used to be 21. It is, however, now 18. Once a child turns 18, that child can take both of his parents, his or her parents, to the maintenance court and launch a maintenance application against them. This often happens in a situation where the child is studying at university, and that child doesn't believe that they're getting enough maintenance and money to pay the university residence fees and so on. There is a legal duty on a party to contribute towards each and every one of the child's expenses. That would include a contribution towards their accommodation, their groceries, their cell phone, their traveling costs, their entertainment. If there's a domestic worker in the house, then the spouse would have to contribute towards that also. The clothing, the list goes on and on. There are obviously different ways to get maintenance in a divorce matter. The most common way and the cheapest way is for a party to launch an application at the local magistrates court. It sometimes happens that in the middle of a divorce, a party also launches a so-called Rule 43 application. This is basically an application for interim maintenance and a contribution towards legal fees. In terms of Rule 43 of the court rules, the Rule 43 application can be launched either before the summons is served, or simultaneously with the divorce summons, or after the summons has been served. It usually occurs after the summons has been served. The attorney would write a letter to the other attorney asking for their client to contribute towards maintenance. Then they still don't cooperate, then that attorney would launch this Rule 43 application. So those are the normal two ways of getting maintenance in a divorce matter: the normal maintenance court route and the Rule 43 route. The Rule 43 route is quite a costly route, however, as normally an advocate is involved and the attorney has to pay the advocate's fees for their appearance in court. Failure to pay maintenance is actually a criminal offense in our legal system, and you can be locked up for it. The court views the rights of the child to be of paramount importance in any divorce matter. So if, for example, a man comes to court and he says that he is spending 7,000 or 8,000 rand on a car installment per month, and because of this he cannot afford to pay maintenance, the court would simply tell him to cut out that installment, because in terms of the Constitution, the rights of the child come first. That's all I have to say on maintenance.